Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, and welcome to another episode of Angeion's Leading Litigator video series. Today it's our pleasure to have Eric Gibbs, the founding and managing partner of Gibbs Law Group, here as our guest. Thank you for joining us, Eric.
Thank you, Steve. I'm flattered to be here.
No, really, it's our pleasure. I want to jump right into it. My first question, and I don't know why I don't ask more people this question, but why class action law, and specifically why plaintiff side class action law?
I probably ended up where I'm at in a bit of a different route than most people. I was adrift in college. I'll just leave it like that, and moved to San Francisco to kind of start afresh. I decided I needed to stop working in restaurants and bars to support myself, and I applied for a job off a job board at San Francisco State, and was hired to work in the mailroom at Leaf Cabrazier, which at the time was about a 4-lawyer firm. And I quickly became fairly obsessed with what they were doing. It just struck me as a perfect example of what lawyers can do to help actual people in a fairly high-powered way, and they were all very independent-minded and impressive people. Really the type of people I hadn't really encountered before in my life, and so that was quite motivating, and it really motivated me in terms of the rest of my college career, and it was my focus in law school. And I've been working in one phase or another of the class action practice ever since.
So let me ask you, at your time at Leaf, was there a particular case or several cases or a particular person that really was the driving force behind that inspiration?
It's kind of a crazy answer, but it was really all of it.
Okay.
I mean, the quality of the people that were there at the time, the commitment to what they were doing was just energizing and motivating. The willingness to allow someone like me who was working, in the mailroom and then, started doing paralegal work to be directly involved in the cases and have, share my observations and views. I was allowed to go to court on a number of occasions. And, regularly consumer frauds, you'd read them about it in the newspaper, go into work, and they would have a group of people in there working on those cases.
Right.
And for a 21-year-old, it's just incredibly powerful and motivating, and you start dealing with the new lawyers that are coming in, and as impressive as everyone was there, you start to realize, this is something I think I could do.
Right. So you said something interesting, which was that you had a lot of direct involvement as a young person, and this is something that I've seen sort of being hammered in by certain members of the judiciary lately. I've seen orders saying that we encourage young associates to be at the next hearing or making this argument. And I was curious your thoughts on that, especially in light of what you just said.
Well, my sort of management philosophy and my just general philosophy, given my own background and experience, and really the quality of the people that I'm fortunate enough to work with, and who, for whatever reason, have chosen to work with me, we really work hard to try to empower people so they're out front, so they can become leaders, and so they're out ahead of whatever their year is or whatever those artificial metrics might be. And so we do a lot of things to put, the younger lawyers or the less experienced lawyers to elevate them in ways I don't think other firms do. So, for example, when we're applying for leadership positions in cases, it's not unusual for us where I'll apply along with another person at my firm, like David Stein or Amy Zeman, to try to secure a joint appointment so that advances their careers. It gives them recognized leadership, and it also sort of formalizes the practical reality of how I run cases, which is the people at that level at my firm are the ones who are doing the day-to-day work. And the work that I'm doing is really more, tactical and focused on resolution, case strategy, case selection, and overseeing the entire practice, to make sure that errors and those types of things aren't happening. But the fundamental goal, from my perspective, and I think this goes all the way back, to the late '80s and early '90s when I was, in a startup law firm,
Right.
is to empower people. Find the right people and empower them.
So that's really interesting, and I think that it's obviously great to hear. I mean, who doesn't want to hear about a firm where the younger attorneys out there are getting empowered, they're getting real leadership opportunities, and they're being a part of the fabric of the cases. That's great. But I want to take it back to something that you said, talking about sort of your role now that this is your firm and you have all these people who are working for you. You're not there writing each and every motion, certainly, and you say
Not even close.
but what you are doing is from your own words, you're being strategic, eye towards resolution, etc. And I feel like that is an area in particular where your reputation precedes you. I look at a case like Hyundai Kia, where you were appointed liaison counsel to sort of wrangle in the divergent opinions and issues that were available in that case. And I'm curious, in your opinion, why is it that you've sort of got this reputation as someone who can build bridges and who can work with a variety of parties to come to a consensus?
Well, I appreciate hearing that I have that reputation to start with. One of the things that we do, I think this goes back in time, is oftentimes when we start a case, what we're trying to do is figure out how do we help people. If we file this case, how do we resolve it to actually help people, to make the resolution, the settlement, the end of the case a meaningful experience for everyone involved, particularly the class members. And I think if you're really holding true to that philosophy, over time people understand that that's not just words on paper, that's actually what they're doing. And so, one of the things we do is we interview dozens and sometimes hundreds of absent class members, sometimes before we file complaints.
Right.
Because we're trying to figure out, is this a problem? Do people care about it? Is it worth the court's time? Is it worth our time? Is it worth our money and our risk, to advance the litigation? Is it worthy of the judicial system to begin with? And so I think those types of things over time, are meaningful. I would also say that, I'm not a table pounder, I'm not a yeller and those kinds of things. I'm always trying to figure out how to solve problems. And one of the things that, became apparent to me in the Hyundai Kia case was that, there was a tremendous amount of animosity between different groups of plaintiffs' lawyers because there was an early settlement proposed, and no one was focusing on whether that settlement was a good settlement or not. They were just focusing on the timing of what happened and how it happened. And as I watched all this unfold, I thought, well, someone needs to focus on figuring out whether this is a settlement that ought to be approved. And the court sort of sitting up there by itself. So the proposal we made was basically that the court should appoint a liaison, not in a traditional liaison sense, so you think of it, but a liaison to basically work between the different camps of plaintiffs' lawyers on the one hand, the defendants on another, and the court on a third. So the court's not, hearing from 22 different lawyers at every hearing. The voices are sort of being funneling through one person. And what that really meant is, a lot of time on a lot of lengthy conference calls
Right.
with a lot of varying opinions and strongly held opinions, and working through those opinions, allowing people's voices to be heard, allowing them, to do what they needed to do to test the quality of the proposed settlement, and we're able to work through that and get it done. that was a very rewarding experience for me, because that kind of work is something I really enjoy doing.
Right. So let me ask you another question. You talk about how you have sort of an extensive vetting process before deciding whether or not to take a case that takes into consideration things like, conservation of judicial resources, and takes into consideration how widespread is the problem. And then on the other hand, we have a bill like H.R. 985, which seems to suggest that the philosophical underpinnings behind that are antithetical to everything that you just explained in your case vetting process. And I was just wondering if you could sort of address that, like the spirit behind H.R. 985 juxtaposed against your particular case vetting process, or even the plaintiff's bar in general, and just talk about that sort of dichotomy, because I think it's a really interesting lens through which to view it, because those seem to be sort of the philosophical issues on either side of that debate.
I mean, I think the practical realities of a modern plaintiff's class action practice aren't part of the voice that's in the public realm.
Right.
What you hear about is these one-off, let's just say it, bad cases, cases that should not have been filed. And those, powerful moneyed interests is who we hold accountable. That's what we do. And so, there's an opportunity for those interests to take these little strings and pull on them and make it appear as if those types of cases are what dominates the practice. It's not true. And what else, the other part is not true is these massive cases that you read about that have great outcomes, which are good for everyone, those aren't really what dominate the practice either. I mean, what dominates the practice is everything that's in the middle. It's these bread and butter cases that mean something to people. And notwithstanding all the lip service about what the tort reform is supposed to do and not supposed to do, ultimately what it's going to do if our opponents get their way is it's going to take all these cases in the middle off the board. So it's going to take the cases, types of cases we file, like we might file a defective auto case that involves 1 or 2 model years of a vehicle.
Right.
I mean, by most measures, that's not an economically feasible case for someone like us to bring, because the risk to the defendant isn't great enough at the end of the day, and the incentive is for them to defend that case heavily, and it puts us upside down. But when we're looking at cases, we're looking at, like I said, we're looking at the quality of the case and whether we can do something that's meaningful to people. And those kinds of cases present that opportunity. And I think sometimes people think we're nuts when we're prosecuting them.
Sure.
But those cases almost always have very good endings. And people write us letters and say, I really appreciate that. I took my car to the dealer 6 times and no one would do a thing for me. So to me, that's a meaningful thing, and that reality is lost, in the tort reform conversation.
Right. So it's clear that the plaintiff's bar is more or less losing the PR war, right? I mean,
I think that's probably right.
How do we get over that? How does the plaintiff bar get over that?
Yeah, that's a good question. I've been struggling, and I do this through AAJ and other groups I'm involved in, and asking the question, how do we govern ourselves, and how do we govern sort of quality of case, and how do we do a better job of keeping some of the litigation that works its way through and ends up on the headlines that probably shouldn't have been in the first place. And I don't know what the answer to that is. The thing, though, what I realize is when you look at any number of industries, there's always people playing at the edges, and that's where criticism, is found. And the same thing happens with class action cases and Rule 23 cases. The other piece that gets lost with respect to some of those cases is they might get filed, and they may make it a little ways, but they ultimately get tossed.
Right.
And that reality isn't part of the discussion, because what that reality really shows is the system's working.
Right.
I mean, the reform isn't going to rid the system of questionable cases. Those will continue, and they'll have short lives, and they'll go away, and people that bring those will learn this isn't a good
Right.
prospect for me to do this. Again, the impact, though, goes the other way, and this is maybe where the voice is lost, is that what I call these everyday bread and butter cases, getting people back 22% of their wages for a year and a half's worth of work with a 12,000 person class isn't making the headlines.
Sure.
But the people that get the check that live in Omaha, that's a big deal. And that voice isn't being heard, and I don't know what the answer to that is.
Well, listen, I really appreciate your insight. I think that most of our viewers, regardless of sort of their affiliation on one side of the V or the other, can't argue with the fact that getting back wages for a rank and file employee is a great thing, and there is obviously a powerful PR machine working on both sides of this argument. Right. But your insights are absolutely valuable, and we're ecstatic to be able to have them here on Angeion's Leading Litigator series.
Well, thank you.
Thank you, Eric.